we are going to the World Cup Commission that is investigating or looking into how things went. And in the course of the week and some part of last week, we have heard travel and tour agencies. There were 3 main travel and tour agencies that were contracted, so to speak, because as we find, there are actually no, as were standard contracts to them. And they were supposed to airlift their supporters and other VIPs from Ghana to Brazil to watch the matches. They have been telling the commission, and one thing has run through, that there were no real contracts, you know, to be signed between them and the Ministry of Youth and Sports or its organizing team, and also that it appears that things had suffered a kind of a mess, and it took the Chief of Staff to come to rescue the situation. The Chief of Staff held meetings with them and eventually decided to find money for them to airlift the fans and all the VIPs that Ghana needed to airlift to Brazil. I'll start here with Abdul Malik.
Well, as I indicated last week,
right,
I would not be too judgmental, you know, relative to the proceedings. I was even a bit worried that sometimes the points made by, the comments made by the chairman and other members were pointing into a direction of indictment before findings were made public. I said that in good faith, based on my own observations. And so one is still very careful. But of course, the things being said, quite messy, you know, and indeed a certain apparent contradiction of what the testimony, aspects of the testimony of the minister. So it's not looking, the picture is not looking good, but I still will hold my fire and not make judgments. But things that are being said, especially by one gentleman, is it the Barmed or so?
Yes, Barmed, the last travel and tour agency.
Yes.
That agency didn't have the opportunity to airlift some of the funds.
Yes.
And it feels that the people were not giving on merits.
Yes, so there could be an element of sour grapes there. That's true, it's human. But he also made serious statements about when you ask for contract, you are told that, look, we wouldn't sign contract, we are members of committee, is the ministry that signs. The picture is not good, let's be honest. So far, it's not good. And I think it was good that this commission was set up and we are all waiting for the finality. But the point about, which we made here last week, I'm told also came up, the contempt powers.
Yes, we'll deal with contempt briefly.
Okay.
We have the footage about their reaction to the contempt, and then we'll deal with it.
Sure.
Yes, Abi, what do you see? Have you been following?
Yes. I saw you representing somebody, and most of the times you will be sneaking in something and he will not be listening.
That's not fair.
That's what I saw.
Go ahead, go ahead.
Something, I heard people say that there was no contract. I am putting on my legal cap. I'm not playing politics with this law. There was a contract. There are different forms of contract. You have simple contracts, you have universal contracts, a unilateral contract, you have bilateral contract, you have standard form contracts. Oral contracts fall under simple contracts. But admittedly, if you are dealing with complex issues, you want to commit them into writing.
Right.
So if that's what is absent, yes. But to say that I orally contract you, and for that matter, you go out to say there's no contract, the fact that a contract is oral doesn't make it less a contract. That is the point I want to make.
Yeah, the commissioners, when they make that point...
does it come in here?
Yes, the State Properties and Contracts Act.
Yes, it doesn't have any rule.
No, I'm making a legal argument.
The commissioner's concern is that they think the systems are is the problem. So they are not really exactly blaming these parties. But they are saying that going forward, they should always insist to have a contract, a proper contract, so to speak. And they are appalled that the ministry and its coordinating officials did not think about it.
Deal with millions of dollars.
And I'm saying that...
Millions of dollars.
Admittedly, you wouldn't want to enter into such complex contracts without writing them down.
Correct.
You are not buying tomatoes. I can go to, that's, you see, when we talk about contract, people think that it is only when a Suma Bandar ship comes from Dubai. The tractor you bought is a contract. The tomatoes you buy is a contract. Did you sign a paper with him? But that is, you can't use that as against government contracts. That is where you would have said that you need it to be reduced into writing. On that score, I feel disappointed because you cannot engage in such activities without committing them into writing. I'm thinking that
the States Proceedings Act, Section 2, says that you can claim under implied contracts.
Yes, which means that it is not expressly written. But again, I think that on that score, there would have been a basic written contract where you can now begin to imply certain things which will make the contract whole.
Right.
Because there are some implied terms. If they are taken off, will not make the contract work.
Okay.
So this aspect you brought in is for the court sometimes to imply that, look, even though the parties have not written it down, but to make the contract work, the workability of the contract, and to ensure that that's the sanctity of contract, courts normally would uphold the sanctity of contract and would imply terms to ensure the contract works. So, but it is too early again because it is his word against the word of the agencies, and so we need to allow the
documentary proof of contracts the way it should be.
Yeah, that's what I'm saying. Is the word of the minister.
They have produced letters, written from the ministry, inviting them and allotting a number of passengers to them to airlift, and making specific requirements as to how they should go about it. And they say to the extent that they complied with the terms of these letters, that's it.
So it will now for the World Cup somewhere last year,
right.
2013.
Right.
All this time, we're sitting doing what?
So it will now depend on the probative value of those documents. How the commission would place weight on those documents. That is also critical.
Okay. Mr. Akoto.
I thought Amaliba said he was speaking as a lawyer, not necessarily as a politician. But at the end of the day, he appears to want to, defend the position of the ministry and whatever it is that they've done, which, from all indication, listening to the way the
I ended up by saying that we agree that you should commit those ones into writing. And so I am disappointed.
So allow me to
But in the absence, you are saying they cannot also seek to exonerate themselves.
By saying what is their probative value, as if those things don't matter. But we've seen, we've read some of the comments which are very clear. And there's something that sometimes we don't realize. We think the commissions are set up only to find fault with people. But from the claims that they are making, they are even asking that some monies that they use to purchase tickets and the rest ought to be refunded to them together with, plus some interest. Because they've gone ahead to do those things. Therefore, for where there was no written contract from anybody, they were just giving, some assurances. You go there for a meeting, say, see my, what do you call it, my spokesperson or my aid and things like that. I think you have a whole Attorney General's department that is there to service and advise the government. So if you have such a business, why don't you just refer it to the agents department? Please prepare some contracts for us, so we could use that one as a basis to do our, negotiations. But individuals, as it were, took it upon themselves. Some names that are being bandied around, we don't even know their official capacity. We're all involved in doing all kinds of things. So I think that it was a bit, is a negligent on the part of whoever was there not to have made use of the services of the AG's department to have assisted them to do this job. At the end of the day, almost all the committees also failed. And I mean, clearly,
the committee chairman claims that even though he was made the chairman of the committee or the coordinator of the committee, members were still reporting to the minister, so he should not be held.
Interesting.
Well, that is interesting. But you see, sometimes when accusing fingers are pointed in the direction of wastage of money or state resources, people don't feel comfortable. But what has happened, if you look at the way things are happening, the kind of stories we are hearing, it's more like somebody was doing his own thing. People were creating the, what do you call it? The opportunity. The opportunity to do things. They just created opportunity to do things.
Judge, briefly. What have you followed? And there's a point where even though this is a Ministry of Youth and Sports, sponsored or supervised project with the committee involved, in the end, it looks like it took the Chief of Staff to get things together.
Well, yes, that's what I'm saying. If I initially I'd wanted to take a fifth, like Kweku did, and say that, these things are still unfolding. So I'm not very comfortable going into details as per information that
It says they are unfolding, but the commissioners are making judgmental comments.
That is the commissioner's point of view. I am saying that normally you want to see these processes unfold, then you, at the end of it all, you can make some value judgment. But that suffices to say, for instance, that, see, I think that we have one fundamental problem that we don't pay attention to in this country: systems. I have always had a problem where, when it comes to our football, we have a situation where we are saying in one vein that the Ghana Football Association are untouchable. And yet, when it comes to all these things, then we are saying that government and ministry should be involved. And that is where we always have our challenge. Because, you see, sometimes they even operate at cross purposes. Now, coming back to these things, first of all, I find it very laughable when the coordinator of the committee says that, well, they were reporting to the minister. You have been minister before. The fact that there are committees in place and then you have a coordinator as head of those committees also doesn't mean that minister cannot call anybody at any point in time and say, where have you reached? That is why in most organizations they'll tell you the chief executive is the ex-official member of every committee. So that is neither here nor there to start.
No, he feels that. For example, if the minister needed to do something, he should route it through the coordinator. There were things that he was unaware. The minister was directly ordering or instructing the others to do.
That is not a point he should hold solidly. Because as coordinator of these activities, even when minister has given an order behind you, if you are involved in the activities of each committee, you should know what is happening. You understand? Yes, but I know. But what I'm saying is that if you are effective, you will know that the minister has said they should do this. So why are you doing this? Then he said minister, so then you can go and reconcile and check. Because
he says there are times when the minister chose who chairs their meeting, so he doesn't get to chair it.
No, but as coordinator of the committees, he doesn't have to chair every committee. He is a coordinator. He is the man to sit down and receive reports and find out where they are and things like that. That's how I understand who a coordinator is. But coming back to the fundamental issue, I believe that, once again, we were all confused as to what we wanted to do to go to World Cup. Let's be very frank about it. Initially, the decision was that nobody was going to go on government ticket, and it was made public. Then secondly, some people, after working around with all its attendance problems, said that, well, we are going to get corporate Ghana to see how many people they can agree to sponsor to go. So you find out that the operation of committee and things like that, that's why you are finding committees firing letters to organizations for fundraising, and sometimes 2 letters from 2 different committees went to the same organizations and things like that. So that was where we began to have our problems. As for the issue of contracts, you see, at any point in time, what I understood, and look, nobody should think that it is only there are a lot of things flying about contracts because everybody wanted a bit of the cake. So if you did not get, then you come out and tell other people that, Charlie, these people, this is what they are doing. And it has happened over time. Yes, but the point I want to make really is that, you see, as these things unfold, we should also be mindful and we're hopeful that the commission itself would recommend a system where we build a synergy between the Football Association itself and the Ministry of Youth and Sport. Because until we find that synergy, we will not make any progress.
Thank you.
I have a problem with that.
Thank
So
you.
you should be careful.
Now let's listen to this quickly by the commission. And it came up because, as we know on this show, Kukubako said emphatically that the commission has no power to punish for contempt unto itself. There is also one, Dr. James K. Ansah, who wrote an article in the Daily Graphic, also telling the commission that as a quasi-judicial body, it was a lower adjudicating authority and didn't have the power to punish for contempt. Let's hear how the commission responded to that.
It has come to our notice that certain members of the legal profession have indicated that we don't have the powers of contempt. I think this is a total misconception. Either this is disingenuous or it flows out of a mind that, sorry to say, demonstrates lack of some knowledge about the position of the law. Now, we are very conscious of our powers. As you know, His Lordship is a Court of Appeal judge. I'm a senior lecturer in the Ghana School of Law that trains lawyers, so we wouldn't do things without knowing, going to the source of our powers. So, for the benefit and the education and edification of those who are watching and those of us in the profession who will love a debate on these matters, let me read CI 65, which is the constitutional instrument that sets out the rules and regulations under which we're operating. And I'm looking at the powers of the Commission. Now, if you look at section 1(6)(d), it says that for the Yes. It was the powers. Yeah, the powers of the Commission. I'm saying the powers of the Commission. It says, for purposes of the conduct of the proceedings, a Commission has the power, and if you get to D, it says to cause a person who refuses to comply with an order or a directive of the Commission or acts in a manner contemptuous of the Commission, to be charged by the Attorney General with contempt of court, and for that person to be tried by the High Court.
All right, so that's the law. He read it, and after he read it, Moses Fuamoni, who is member of the commission, after he read it, made it clear to the journalists that, as he said, those who are saying they do not have the powers are wrong. Perhaps maybe I start with Kweku. I wanted to start with Aiku too because he's a senior lawyer and former Attorney General. But because you said on this show that they don't have powers, I don't know how you
He didn't contradict what I said. The emphasis was whether they had powers to punish people for being contemptuous of their proceedings. And I said they didn't have it. You can bring the person before you to explain himself or how, but read this thing carefully. It says to cause a person who refuses to comply with the directive of the Commission or acts in a manner contemptuous of the Commission to be charged by the Attorney General with contempt of court, and for that person to be brought to be by the High Court. That's all I was saying. The point I was making, the extension, was that in order to prosecute somebody for contempt of the Commission, that cannot be exercised by the Commission itself, and that it ought to be done by the Attorney General before a High Court. So the fact that the Commission has the powers of the High Court does not give it the jurisdiction to try anybody before it for contempt. That's all I said. In fact, this thing he read actually reinforces the point I was making. There's no basis for a debate.
Okay. So in that case, you know, Moses Fuamoni, you know, even before he started his comments, said that all who are making those comments are not properly educated on the process.
Well, if I should hold a little brief for him, but as what he was trying to say is that if we are to cause the person to be sent to the High Court, then the person must be brought before us first. It is for us to inquire, to satisfy ourselves that what he has done is contemptuous. Then we'll refer him. So to say that we can't even bring him before us may be problematic.
But I didn't see that.
No,
Okay.
I'm only trying to say if I would brief for him.
Okay.
But what he has read clearly shows that the power does not lie with them. Because the Constitution is clear under Article 126 that it is only the superior courts that have power to commit for contempt to themselves. And that anywhere contempt arises, you have to send it to the High Court.
Okay.
So clearly,
you
they
are
don't
saying
have
that by
power.
procedure,
Yeah.
they inviting the journalist to the place
Yes.
and asking the journalist to explain himself was correct.
Yes, because
That
to
ought
cause,
to be done before
Yeah.
they refer the person to the
how
Attorney
can you
General.
cause a person who has acted in a manner contemptuous to be charged? But when you have not even investigated the facts, so it should be brought before you. You won't find out from him whether he really knows what he said, he meant it, and he wants to stand by it and all that. They say, aha, so you are insisting. Okay, we are satisfied that you are in contempt. So we're now referring you.
Okay.
That's not different from what I said.
Exactly.
No,
exactly.
I'm saying
But-
that for anybody to say that they don't even have power to summon would be problematic.
No, but I considered
can-
that they could bring the person before them. I said so.
And the position you have just said and what Mr. Ikutu had just said, I've heard lawyers say that even that is wrong, that by the process, if you suspect that what the person has done is contemptuous of the commission, the law is that you refer the person to the Attorney General. Then the Attorney General will file the requisite processes at the High Court, at which place the person will be invited formally to either justify or if he wants to apologize. I don't know what you think,
But is it not
Amalba?
fair to give the person an opportunity
The
before the
procedure-
commission? Is that fair? That's fairness. It's maybe not
hear
law.
Amalba too.
There are two procedures when contempt matters come up.
Right.
One is for the court that has a jurisdiction here in the High Court to punish that person right in the face of the court. Instantly. That is to say, if the contempt was committed in the face of the court. The other one is what has been alluded here, to refer that person to the Attorney General Department for a proper charge sheet to be prepared and served on him for him to come to court.
And we have precedent, like in the Liberty case, Republic
Yes.
versus Liberty. The person was referred to the Attorney General, and the Attorney General now filed the committal processes in the court.
So depending on the nature of the contempt, one is that the court can seize that jurisdiction and punish him right in front of the court when the contempt is committed in the face. The other one mostly is when the contempt is committed outside the court. Then you proceed by referring the matter to Attorney General. But in this instant case, I think that how do you come to the agreement that there was contempt of the commission? The commission members must be satisfied of that before they can refer the matter to our Attorney General. And indeed, sometimes too, because there's a possibility of purging yourself of that contempt, when you come and you are able to purge yourself and ask for forgiveness, just as my senior did the other time for Sir John, then they may drop the matter and will not refer it to. So I think that
is the purging not supposed to be done in the court?
no, they have the power to refer you. So they can also relax it. You know, because whom did you cause pain to? Whose administrative justice did you impede? Is the commission. And they are the commission members. So if you're able to assuage their pain, they may forgive you and they may not refer you to. But to punish, I think, yes, CI cannot.
But the comment of those who are saying this is that when the gentleman was brought, the journalist was brought before the commission, there was a threat to get the police to arrest him.
Really?
Yes, right there.
Oh yes,
Wow.
but how do you refer the person to?
Maybe the commissioner, the chairman, just made it as a joke, but he stated that he would hand him over to the police.
No, yes, but how do you refer him to the matter? You take him to the police. Why would leave him and he goes and runs away to Burkina Faso? So you get him and then hand him over to the appropriate
Well,
authority.
he can't go to your village.
My village is still in Ghana. So the point is that if that comment was made that he will hand him over to macho men, that is where you have a problem. But he's handing him over to lawful authorities.
Okay. Yeah. All right. Yes. What do you have to say?
No, I think that I agree in the main with Amaliba because basically, first and foremost, There should be a prima facie issue as whether there has been contempt or not. Well, okay, okay.
All
All
right.
I agree with Garcia. And because yes, because sincerely speaking, what is the determination? What if the man came and said, "Oh, no, is that what you heard? I'm sorry, I didn't say it." Or is that what the newspaper quoted? I never said it. And if you remember, in the Sir John case, Supreme Court, the first question that was asked, the question was, what says you?
How do you answer to the charge?
Yes, how do you answer to the charge? How do you answer to the fact that this is what you have said?
Okay, so in that case, the person is already charged and is answering to the charge.
No, I'm saying that you've been summoned before. Come and tell us, what do you say about what has been said? Then you say, oh, my lord, did they say, you remember that somebody was left off?
From Kumasi.
Yes, somebody was left off because eventually it turned out that he wasn't even around.
No, but that example may not work because that court, that was the court and that was the Supreme Court.
But what I'm saying
and
is
the
that
punishment came right there and then.
What I'm saying that, you see, he made a certain display. He said, in facial Korea and ex facial Korea. That means that in the face of the court or outside.
And the ones you are referring to were all ex facial.
Yes, and I'm saying that, you see, the Supreme Court, the Supreme Court's case was maybe because it's the Superior Court. I mean, they are the very top and they can
have the power to do it.
But I'm saying that in the commission, maybe the chairman of the commission has been called and said, look, Kwaku Baku on today's Newsfile said A, B, C, D, E, F. He wakes up Monday morning, banner headline, Kwaku Baku does this. Wouldn't you think that, like Kwaku said, even if you take away the legal substance and say even fairness, is it not fair for them to say, Kwaku, this is what you purported to have said? Did you say it? Then he says, oh, I said it. Are you sure this is the reflection? Yes, I still stand by it. Then at that point, the commissioners will make a decision whether they think that you are in contempt.
At that point, is he answering to a charge or he's not?
No, at that point, prima facie, you are establishing.
Okay.
Yes. And then, like Maliba said, of course. Let me give you an example. You see, when you go to Uganda, and it's something that I pray one day it comes to Ghana, Public Accounts Committee of Parliament, they are sitting, and there's a police, maybe like 4 or 5 policemen sitting quietly behind them. Then Auditor General makes a finding. This one looks at this one, this one looks at this one, asks you a question. If you are not satisfied with the answer, they hand you over to the police immediately and it takes you away. That's what they do. For the Attorney General to now go and investigate whether really what, and if they want to charge you, they charge you. But then the police takes you away.
Okay.
So it's about the same thing.
But let me make this point. It is not the case that an individual cannot, a party in a case cannot cite another for contempt.
Right.
It is not a case that every time the thing must have to go to the AG. And the Supreme Court has settled that matter.
Right.
I think the Supreme Court Law Report, Ghana Law Report 205 to page 1. It's settled it clearly that the power to punish for criminal contempt, the power given to the AG to pursue criminal matters, to prosecute, is completely different from this criminal matter.
Okay.
So by this one, we are only respecting the law. This is what the law says ought to be done.
Okay. All right, so that's some education for all of us. And